If you're a service member or veteran and you believe your employer violated USERRA, one of the first questions you probably have is this: do I have to sue my employer, or are there other options? In this video, I'm going to walk you through the two main paths in a USERRA claim: pre-suit negotiation and litigation, and what each one actually looks like in the real world. Now, first let's talk about what USERRA protects. USERRA is a federal law that protects service members from discrimination because of military service. It also guarantees reemployment rights after deployment or training. Some common violations that we see include things like being fired after deployment, being denied promotions, loss of seniority or benefits, or being treated differently after your service once you return to work. When these things happen at work, you do have options. We'll call option one the pre-suit negotiation. Now, in many USERRA cases, the first step is this negotiation, and this means that your attorney reaches out to the employer through a formal demand letter or a less formal process and explains exactly how the employer violated USERRA, what the evidence shows or what we think it shows, and what needs to happen in order to resolve the claim outside of litigation. This might include things like reinstatement, back pay, lost benefits, or compensation for things like emotional harm. Now, pre-suit negotiation can be effective for a few reasons. First is that USERRA is a strict federal statute, and many employers don't even realize they're violating it. Second is that employers often want to avoid litigation once they understand the risks, particularly in these cases. That said, pre-suit negotiation only works if the employer is willing to engage in good faith. If they deny responsibility or minimize what they did, litigation often becomes necessary. So that brings us to option two, which is litigation. Now, if pre-suit negotiation fails, or if the violation is very serious or the damages are really significant, litigation may be appropriate out of the gate. This means filing a lawsuit in federal court alleging these violations of USERRA. Once a case is filed, several things happen. First is discovery and the process of evidence gathering, obtaining emails, personnel files, internal communications, taking depositions from supervisors and decision makers. And this is often where the truth comes out because employers have to explain under oath why the service member was treated differently. Next, there may be some motions by the employer to try to dismiss or limit some of the claims. Many of these motions are denied, where there's some evidence of discriminatory motivation. Sometimes they're granted. But throughout litigation, settlement discussions can continue, and many USERRA cases are resolved before trial once the employers sees the strength of the evidence. If a case does go to trial, a judge or a jury will decide whether military service was a factor in the employer's decision, and if so, the employer can be held liable for damages. It's important to understand that USERRA uses a standard that requires that you not have to prove that military service was necessarily the only reason for the employer's action, but that it was one of the reasons. And once the showing is made, the burden then will shift back to the employer, and they have to prove that they would have made the same decision regardless of your service. And that can be a high bar, which makes USERRA a very powerful law for employees. So you ask yourself, which option is right for me? And the answer is, there's obviously not a one-size-fits-all solution here. Some cases resolve relatively quickly through this pre-suit negotiation process, while others require longer litigation in order to hold employers accountable and to protect your career. The right answer depends on the facts, the evidence, what the employer looks like, and how they respond when they're confronted with the law. The long and the short of it is that if you believe that your employer has violated USERRA, it's important to speak with an attorney who understands both the law and the practical realities that service members face, and what litigation versus pre-litigation resolution actually means and which can help you. An early conversation can help you understand these options, preserve evidence, and decide what the best path forward is for you and your family. If you have questions about a USERRA claim, reach out to us today for a confidential consultation.